Okay? Remember, our hero came down and he basically said, well, I'm going to accept that for value, return it for value, and I'm giving you a bond to settle and close this matter. Remember, what did the attorney say in his motion? Didn't he say that the defendant had agreed to accept and pay the debt? Yeah. What happens when you do an acceptance? Don't you make the statement that you're going to handle a matter? And if it's for settlement and closure, then you better do something to settle and close this thing, right? Okay. So the attorney is saying to the court, I want you to strike all of his nonsense. And I want you to bring a judgment against him for the $31,000. Now, you're Joe Patriot that did the acceptance and the return and he asked for settlement and closure. What's your position now? I want it settled and closed. How am I going to get it settled and closed? Well, the judge has been asked to bring in a judgment of $31,000. What difference is the judgment going to be based differently than what the plaintiff asked for in his complaint?
If the defendant offers some substance.
You should be on the mic, too.
If the defendant offers something of substance to turn the case around and take it away from, or put the ball back in the plaintiff's court so that the plaintiff has to do something with it. Right now, the plaintiff has brought in he's brought in claims, and the defendant has not raised anything of substance to argue the claims or to negate the claims.
Okay, hang on a sec. Did the plaintiff bring in a claim? No. Why didn't the plaintiff bring in a claim? Because there is no money.
Okay.
And so he can't bring in a claim. That would be a violation of James 4:11.
Okay.
He'd be charging his brother. The plaintiff brought in an allegation that the defendant had created some commercial instrumentation that he might be liable for.
Okay.
To see what the defendant might do with that documentation once it was presented to him.
Okay.
And the defendant, or the operator for the defendant, quite appropriately didn't argue against it.
Right.
And in fact, didn't really even dishonor it. He just did what the attorney for the plaintiff said was a confession.
Okay.
Is that not correct?
Right.
So let me ask you a question. In the redemption process, which of course is not valid and no good, and it's just wicked and terrible, and the Messiah never redeemed anyone, in the redemption process, aren't you supposed to agree with your adversary quickly and be responsible?
Right.
So aren't you supposed to confess it?
Absolutely. But
so isn't the attorney for the opposite side making notice that the operator for the defendant confessed the paperwork?
Right. But he hasn't put in his avoidance.
Well, he didn't put in any avoidance in terms of a defense.
Right.
But at least he's in a confession.
Right.
Isn't that the first part?
Right. But he hasn't finished it.
Okay. What is he going to do to finish by an avoidance that's going to honor all the parties? Let's presume to know where this is going to go.
Okay. what he should do is put in some type of an affidavit, whether it be a negative averment.
Nope, beep. See, the only affidavit of negative averment he can put in on this matter is what affidavit? What would he say?
Yeah.
The only thing he could say that'd get him out of this is, I didn't receive the goods. That's probably going to be a lie, isn't it?
Okay, then what?
Yeah, it's colorable. No, he received the goods, he just hasn't got title to the goods.
Can he put in a request for a proof of claim
No,
that the document
because now he's arguing.
Okay.
See, look, dagnabbit, the guy's probably got the goods in his garage.
Right.
This process is not about being thieves.
Right.
How is he going to make it good?
By using his exemption.
Thank you.
There you go.
Absolutely true, by using his exemption.
He couldn't reverse what he said there and all that stuff and just backtrack?
Backtrack to do what?
Fix his problem.
What's his problem?
He doesn't know what he's doing.
No, he's doing it perfectly. He didn't believe he was doing it perfectly until I told him he was doing it perfectly. See, look, if you're going to be a thief, try to wheedle your way out of it. That's not what learning the law is all about. If you get goods, tender consideration on the goods. What is the consideration he needs to tender on the goods? His exemption. Or he can go out and work for Federal Reserve and pay the account off that way like everyone else does. He's got his choice. He can work in law with his exemption. He can work in equity with his Federal Reserves. Or he can be a thief. But he's done everything correctly. That's the point. See, people do not understand when they're winning a case. Yes.
Well, this guy is redeemed then. Is that the idea?
What is your definition of redeemed?
Well, he can offer his exemption, and if you're not redeemed, I don't know how you could offer an exemption.
Absolutely true. Now, why would the AGL say the redemption process is bogus? Because they haven't been redeemed. Because they haven't asked their account to be closed by the Messiah. So is the ADL absolutely truthful when they say redemption is bogus? From their point of view, you better believe it.
What does someone who isn't redeemed do in a case like this? I mean,
Then they become a slave and pay their debts like everybody else, or they're a crook.
well, suppose that in a certain case you're absolutely right. How do you stay in law and without having to give an exemption? And
You can't stay in law without giving an exemption unless you're going to work in equity to pay it off.
so, in other words, when do you switch from law to equity?
You can't go back and forth. You're going to be one or the other. Otherwise, you're a double-minded man. I'm a free slave.
I thought what you get is redeemed. If you're not redeemed, you get it.
Run that by me again.
Well, I lost my train of thought on what it is, but I'm talking from for all the people that aren't redeemed. And what, in other words, you say at the end you go to equity. You start out in law and you go to equity for your
Every remedy
that's
is in equity
right.
after washing your hands at law.
Well,
The law says, thou shalt not steal.
right.
How can you get an equitable remedy when you've taken consideration and given none in return? you haven't washed your hands in law.
Right.
Everything you're doing is a procedural argument, and the procedural argument has no substance to it.
But
What this attorney is saying in this paperwork we're reading is just that you are a lot of equity and a lot of procedure and no substance. So consequently, the court can go back to a judgment in law because you've waived your remedy in equity by not having used the law. So we'll execute against you.
okay, now say I'm a person that isn't redeemed, which I'm not, and I keep in law and I go in law, but I think you said last week you have to get your remedy in equity even though you start out in law, and
The courts are all courts of equity.
Okay, so you have to get your remedy in equity, but you start out in law. Is that?
You have to wash your hands in law. And the original pleadings are a combination of law and equity, facts and assumptions.
Yeah. So, but when you're getting your remedy, you have to go to equity.
Because that's the only court that exists there is courts of equity.
Right.
To which the judges can go to law if that's where you have pled your case.
But that's what you try to keep it in. You try to keep it in law.
That's the criteria you want the court to decide the case on.
Well, yeah, you want to be innocent and you want to go to Rule 11 and you want to stay in law as long as you can.
And you want the true facts to prevail.
Yes.
Instead of assumptions and presumptions.
Right.
And if you do that, the court of equity can grant you the relief.
Right.
Okay.
Okay, so in other words, you stay in law until you get your relief through equity.
Mm-hmm.
Okay, that's all.
Okay?
I don't have to be...
You mean civil procedure? Is that what we're talking here?
All of the rules in the statutes of civil procedure, criminal procedure, commercial code are just resolving the conflicts between law and equity.
But that procedure is your law part to the equity, is that correct?
Well, there's several procedures in the rules. There's procedures for equity, there's procedures for law. You get to take your choice. But whatever you choose will be used against you. And if you choose the procedures for law, you better have the facts and the evidence to support those proceedings to get your remedy in equity. Otherwise, you will go under the rules of equity by assumptions and presumptions and get an execution in law.
So the civil procedure is just all colorable, but it is
Absolutely.
a procedure. It is a procedure to get to one or the other.
Absolutely.
So when you decide to that point, you have to either do the equity or the law part.
Yeah, and it's up to you to understand what you're doing and keep doing it.
So you
Otherwise, you'll get confused and be jumping back and forth. You'll be called a man who's double-minded, which means you're a lunatic. That's when the court can start having some fun. What the court is doing here is basically telling this guy everything he needs to know. And when the guy faxed me all these documents, he said, "Man, what am I doing wrong?" I said, "I don't know. Looks to me like you're doing everything right, as long as you know where you're going from here." See, the whole issue is this lawyer is saying to the court, have the court grant a monetary judgment for $31,000 some dollars. What happens if the court grants that judgment? What has just happened in terms of commerce? We've got an assessment. We haven't closed the books. We don't know what the ledgering is. We've had an assessment by a third party. What does an assessment tell you in commerce? The assessment establishes a liability. What does our hero want to do in terms of this whole commercial occurrence? What's he want to have happen? A settlement. How's he going to settle it? There is no money. How's he going to settle it? Going to settle it by a bill of exchange, which is an order to transfer funds in the ledgering of the accounting to close the accounting. Now, if there is no money, where is the ledgering and this transfer coming from? His exemption, which is a prepaid account. It was prepaid when money existed, because there isn't any now. But since it was prepaid when money existed, that makes sense. And he's authorizing by the draft that whatever it takes to ledger the account come off of the prepaid exemption.
I read in the use, you see that the definition of money is whatever the government establishes it as.
That's correct. The government's an illusion, so whatever illusion they want to cause is what the illusion's going to be. Don't go there, or you've already fallen into a trap again. There isn't any. If there isn't any money, and the government said, it's whatever I say it is, did that just create some?
Yes.
No. Because there's nothing there. Space is a vacuum, and I say there's a ghost there. Is there a ghost there? No. There's nothing there. But since we're at assumptions and presumptions, I can tell you whatever I want to assume and presume. Does that make it real? No, but I don't want to argue it. But if you want to believe it, more power to you. Keep reading. They'll stack your head so full of illusions, pretty soon you'll think there's something up there. Well, in your case, Caleb, I'm not so sure. There's not many illusions up there, Caleb. Okay? So, in reality, when this judge, if this judge or this court comes out and says that there's a judgment of $31,000, they have just created a pre-existing debt. Once a pre-existing debt occurs, can one use the bill of exchange on a pre-existing debt to request a settlement, ledgering, and closure? Yes. Can you use a bill of exchange on a debt which doesn't pre-exist? No. So the best thing that can happen to him in this case is to get an assessment officially by the court. So if the judge came out and said the debt's $31,000, that's what we've been waiting for. Because up until then, the plaintiff didn't bring a claim. Where is the second witness that the defendant ought to pay anyone anything? You understand? Look at it this way. If the bill of exchange, the way it's being used here, is going to access a prepaid account, is the prepaid account substance? Is there anything in the world that these banker lunatics are doing that deals with substance? No. So when does whatever the bankers are dealing with become the equivalent of substance? When there's a second witness to it in the public. Which is what the court judgment is bringing out. So then it can be closed off and discharged. So when the lawyer said, look, this guy admits he's got a bond, he wants to cover it, he said he accepted it, he's got no estoppel in any defenses, he hasn't raised an affidavit saying he doesn't have the merchandise, let's just forget all this crap, let's not even waste our time with a jury, let's just go to an assessment and get on with it. What part of the case is our hero losing? None. He's done everything perfect. And that's what I said. I said, my God, you're doing everything great. I said, I think you're working too hard at it. You're beating yourself up over winning, but other than that, you're doing everything perfect. It's going you got them in the palm of your hand. Let them get the default judgment. It's exactly what you're looking for. And he goes, I never thought about it that way. I said, okay, maybe you ought to start thinking about it that way. Question?
The bill of exchange, the BOE, it's not the same as the accepted for value, return for value and consideration, is it? Because it's more of the accepted for value is more of a paper thing back and forth.
Okay.
Compared to a bill of exchange, which is really equity.
You're absolutely right, they're not the same.
Okay.
First, somebody makes you an offer. Then somebody accepts. What do you now have? An agreement or a contract. The contract calls for performance by both parties. And at the performance, on the substance side and on the shadow side, requires consideration in both the substance and the shadow side. The performance on the substance and shadow side by cross-consideration is carrying out the contract. It isn't the contract. The contract is the offer and the acceptance. Then you carry out the terms of the contract, and in carrying out the terms, consideration is exchanged. Now, what basically the plaintiff's attorney said is, darn, we had a contract with this guy and he promised to deliver some payment. What's the payment? The shadow or the substance? The shadow. The substance was the merchandise and the title. You understand? So what the lawyer is saying is, look, the guy got a new television set, a whole rack of clothes in his closet. He got his automobile fixed and fuel to go back and forth from Ohio to California. So he got substantive consideration. And then we got the consideration of his signature on the receipts, which were the shadow. Now he possesses the substance of the goods and services, but he won't tender us the Federal Reserve notes. So who's got the cause of action?
Because he has debt, and the Federal Reserve notes are debt. It says.
Well, he could replace one debt with another.
Right.
Is what they would do. Take one liability and slip it in for another liability.
That would be the
but
Federal
he
Reserve
didn't do that. He didn't give up enough liabilities, so they're really ticked at him. Because remember, a liability to a corporation is an asset, because they're an idiot.
And that liability was the Federal Reserve note. Because
Absolutely.
It doesn't say payment on the note. It says all
IOU.
debts.
Yeah.
Public and private. It doesn't
Absolutely.
say payment for.
So the corporation wanted to get killed. And he wouldn't kill them by giving them any debt. So they're really upset. And so they had the cause of action, and he goes, okay, well, let's do it this way. I'll accept all of that stuff. And so now the court's going to come out with an actual assessment, a double witness on the public side. And once that's done, he's not going to replace a liability with another liability. He's going to go in and he's going to say, close that puppy down, I'm going to give you an asset. Now, once he delivers an asset to close that account, what happens to the title to the goods and the services? He gets legal title to that so that equity for all parties prevails. So the public's no longer the trustee over all the titles to those goods and services per se. He just chose to go to law instead of to equity. But he's doing everything correctly in order to get there. Because remember, in Genesis 23, you've got Abraham, and he wants to buy a parcel of land in a foreign kingdom, and he wants to actually have legal title to it, doesn't he? how is he going to get legal title to the land in the foreign kingdom? Pay for it with substance in front of the public. So if our hero wants to have legal title to all of the goods he got with the credit card, he has to get the public to witness it, and then he's got to give them an asset. Is that what he's doing? Then I'd say he's winning. He's right on schedule. What's wrong with what he's doing? Where's the asset, huh? Show me the asset, not the money. Okay? So, at this stage of the game, the attorney was moving for summary judgment. Notice it's not a default. It's summary judgment. Why summary judgment?
No trial.
Because default is without a trial too. What's the difference between summary judgment and default judgment? Default judgment is based on procedure. Summary judgment is based on the merits of the case. If there is summary judgment on a case, can a case be retried? No. Once decided, always decided. If it's a default judgment, can it be reheard? Absolutely. So the attorney is helping him out, saying, if you want lawful legal title, let's go to a summary judgment and don't dispute it. Because you're going to get title if you do it right. Yes, comment.
Then did he get redemption with reconciliation? And if he didn't, and he would have paid with Federal Reserve notes, would he have only gotten reconciliation and no redemption?
Yeah, because he can't pay with Federal Reserve notes because that's going right back to substituting a debt for a debt. Okay? He's got to stay on the asset side. If he merges any of the assets with a liability, then it's all a liability. Brief in support of motion to strike. Defendant admits via his pleadings and correspondence to owing the plaintiff $29,669.72. Defendant has presented the court and plaintiff with a defense of payment via a patently false bond. Once again, our attorney is saying, hello, duh, understand what you're doing. Bonds are for a second witness surety. They're not drafts and payments. Then he goes on and says, defendant opened a Chase Manhattan Bank credit card and charged goods and services in excess of $22,000. As of this date, defendant has not paid anything on the outstanding balance. Let me ask you a question. Are all those facts true?
Yes.
Absolutely. Not one of them are false. I asked this guy and he said, oh, duh, yeah, they're true. Argument. The plaintiff has pled an account stated. An account stated arises from goods and services sold on an open account. That is, the debtor received goods or services followed by an invoice to which the debtor did not object. This lack of objection to a legitimate bill makes the account become stated. Let's get away from this for a second. Isn't there a provision in the UCC that says if a party to an account sets a notice to the other party of what the balance of the account is and the other party doesn't object within a given period of time that the account is what the party stated it to be? That's why there's invoices and statements. You're absolutely right. Because the invoices come out, you generally have 30 days to get an invoice corrected. And if it isn't corrected, it appears on the statement. And the statement generally cannot be argued. Generally. Unless you can show good reason. This lack of objection to a legitimate bill makes an account stated. A verified open account complaint creates a prima facie cause for a case as a matter of law under state statutes. Many open accounts contain dozens and sometimes even hundreds of entries. A suit on a contract requires proof of each transaction. A suit on an account only requires proof of the existence of the account and thus throws the burden of pursuing a particular objection to a transaction on a defendant, substantively reducing the plaintiff's burden in making a case. Then he cites case law. The defendant's answer consists of an admission of the debt. How did he admit it? He accepted it. But claims payment via a phony bond. Bonds don't pay. There has been no payment. And defendant's answer consists only of general denials. The defendant has not answered as required under the court rules. State statutes require, quote, each denial must state the substance of the matters on which the pleader will rely to support the denial, unquote. Defendant's answer in response to plaintiff's complaint simply stated a general denial without any support or substance to the denial. Certainly, the defendant had personal knowledge of the 50 months of account statements, 4.5 years without an objection, and such general denials coupled with personal knowledge are considered in effect admissions. It is appropriate when the defendant files a general denial to a verified complaint. Oh, verified? Who verified it? The attorney. He's got his bar number. That's a bond. On an account stated for the plaintiff to seek a summary disposition pursuant to state statute. The defendant had every opportunity to object to the 50 months of charges pursuant to the credit card contract, but did not do so. Now the time provided under the contract is long expired and defendant has no defense. Wherefore, plaintiff requests that defendant's answer be struck and or summary disposition be granted pursuant to state statutes in favor of plaintiff in the amount of $31,138.17, which is inclusive of damages, plus interest of $1288.48, costs and attorney's fees of $200 respectfully submitted. Affidavit. The attorney, first being duly sworn, states as follows. Oh, I know there's a bunch of patriots turning over right now. I can't tell you lately how many times I've heard patriots yelling and screaming that under the rules and regulations, attorneys cannot make affidavits in behalf of their clients on the claims because they do not have first-hand information. What is wrong with that stupid position? Pardon? Now, what's wrong with that stupid position? Oh, isn't it a great argument? Does the attorney have first-hand information? No, he doesn't. That's true. But it's an argument, yeah. But so what? Who cares? Who's got a duty here? The defendant or the plaintiff? The defendant. Why does he have a duty? He hasn't rebutted the presumption. That's the whole problem. And until he rebuts the presumption, does the plaintiff have any obligation? No. So if the plaintiff never appears with an affidavit, who cares? If it looks like the plaintiff is appearing through an attorney, which has no capacity to do anything for the plaintiff, who cares anyway? Because the plaintiff has no duty, certainly his attorney has no duty. Right? But the attorney did show up just to make an affidavit, just to piss off the average plaintiff anyway. I am a member of the state bar. I make this affidavit in support of plaintiff's motion to strike. 2. The following facts entitle plaintiff to a summary judgment. A. Plaintiff's assigner, case Manhattan Bank, extended credit to defendant under account such and such at his residential address of such and such. B. Defendant received over 24 months of account statements indicating various charges and payments. C. The defendant did not object to any of the charges, terms, or conditions pursuant to the contract of credit with plaintiff's assigner. D. Defendant filed a notice of copyright in his name and a bond and discharge as a responsive pleading. The documents filed were patently false and made no legal sense. And that's a conclusion. So we'll just kind of like, it didn't appear there, but it's there to really tick him off to see what he'll do. Okay? But it's not a valid part of an affidavit because it's just put there as a test. It's like throwing bait overboard from the ship to see what we're going to catch. E. Defendant's response was an admission of the debt owed and does not constitute an answer. F. Numerous demands have been made on defendant to pay, but defendant refused. G. Defendant has paid nothing on the balance due, leaving a total amount due $29,669.72 plus $1268.40 interest at a rate of 13% per annum from the date of filing of this case, plus costs of $125, statutory attorney fee of $75 for a total judgment amount of $138.12. This guy is really busting his butt for $75, ain't he? Hey, man, $200. Well, that's $125, which is a statutory cost, and $75 for his fee. He wrote all this paperwork for $75. I'm sure the bank's kicking back something. But isn't this fun? Certificate of service. He actually said that, I actually laid this on the hands of the guy, the defendant, and so there we go, okay? Now, are we having fun yet? Now, the guy gets all this stuff in the mail and he goes, oh man, they're not listening to anything I'm doing, they're not paying any attention, what's going to happen to me, woe is me, oh, the whole world is crashing in on my head. And I'm going, I thought you had them feeding out of your hands. Isn't this what you wanted them to do? All he needs to do now is get the judgment and settle a claim. But don't do it through the stupid bond. That's not a draft. Okay? So we'll see where our hero goes with this one. Okay? We're about down at the end of the evening. There was a really interesting movie that came out this weekend. It was actually the best movie out this weekend as far as taking in money. And it was Once Upon a Time in Mexico, which is the Rodriguez film, which is like a part 3 of Mariachi, and then the other one. It's always a shoot 'em up, bang up process. And this one here, I gotta tell you, was very interesting. Because you've got more groups, persons, and entities buying in so many different directions in this story, it takes about a third viewing to actually see who's on first and what's on second. Our hero, the same actor who was in Pirates of the Caribbean, Johnny Depp, plays an FBI agent in this movie. No, he doesn't, a CIA agent, down in Mexico. And he is every patriot's presumption of a government official. Because he ain't exactly doing nice things. He is drafting everybody to do everything to create so much confusion and problems that you have no clue and idea where this thing's going. And one of the parties that Johnny Depp drafts as a CIA agent is an ex-FBI agent who happens to be in Mexico. And the FBI agent used to be involved for the FBI in Mexico and the United States of drug trafficking. And the story of once upon a time in Mexico, Mexico is a metaphor for the world. And the problem that we see going on in Mexico is chaos, which I think you would probably admit is a parallel to what's going on in the world. And our hero, whichever person that is, there's probably a couple of them. Really our hero is Mariachi, the guy that's played by, pardon? Antonio Banderas. Yeah, I actually expect him to be in this movie a lot. He's in this movie really very little. And if you expect Selma Hayek to be in this movie a whole bunch, which you'd like to see more of, she's hardly there at all too. But that's okay, because it's a great story. You see an awful lot of Johnny Depp, because he's creating all the trouble. And as Johnny Depp so carefully analyzes it for us, the problem in Mexico is the cartels. Which, as far as the patriots are concerned in the real world, would be who? Federal Reserve, the IMF, the United Nations, everybody else. And they're all financing everything to push their profits on their activities, i.e. drugs. Well, what's the one world government pushing? Control. Same difference. Okay? And so Johnny Depp wants to, even though he's working for the CIA allegedly, he wants that the cartels get what's coming to them. Which is basically to say that they're going to run around, spend a lot of money, and act like big stuff and get nowhere. And so that's Johnny Depp's goal. And to do that, he's got to create a lot of confusion by causing a lot of people a lot of problems. So what else is new? Now, Mariachi is basically just a nice dude with a guitar that spits a lot of violence, but all he wants to do is relax and play his guitar and meld into the background and have a nice life, especially now that he's found Selma Hayek, who's supposed to be his true love. And Mariachi is more a legend than reality. Nobody really thinks he's reality, but everybody knows he probably exists there and he comes out whenever he's needed. And so part of the goal is to blackmail Mariachi to come out, and the goal is to assassinate the President of Mexico. And the cartel wants to assassinate him to get their man in as President of Mexico. So what else is new about cartels? Every election, the one world government puts their candidates on both sides. It's a shoo-in. But see, Johnny Depp, even though he's the evil guy, everything's backwards, so really he's the good guy. He's trying to get the cartel's choice out, even though you don't like what he's doing. And so Mariachi and his band is supposed to go in, and they're supposed to be at the presidential party when the evil guys are supposed to come in and assassinate the president in behalf of the cartel, and Mariachi and his people are supposed to be the assassins hired to assassinate the president, but in reality they're going to get the bad guys that are going to get him. That's the theory. And of course Mariachi and his friends are expendable. Who the hell cares whether they live or die anyway? And if, in fact, the bad guys get away with killing the president, who's going to be blamed for the assassination? Mariachi and the good guys. So you never can tell who's on what side and what's happening. But the reality of it is that they have picked on Mariachi and his friends one or too many little times, and done some very dishonorable things. So the name of the movie is Mariachi and his two friends have got to save the president, save the country, save themselves, not get caught in doing the bad guys at the same time, which makes it a very entertaining, good film. And that's probably about all I'll tell you about it, other than the fact that there's more substance to that story of mass machine guns coming out of guitar boxes than what the newspapers might want to make you assume and presume is going on in just a spaghetti western type story. So I think its popularity for the weekend was well deserved. We should be back here next week, God willing.